I'm going to call to order the 106th meeting of the Standing Committee on Citizenship and Immigration as we continue our study of the Immigration and Refugee Board's appointment, training, and complaint processes. Begin by thanking Ms. Jacobs for returning after our last meeting and being available. Unfortunately, your colleagues who were also witnesses the same day are not able to come, but we're glad you are here for questions from the committee. In our first hour, we'll begin with Ms. Warner, who has a statement as the coming from the Canada Employment and Immigration Union as the National Executive Vice President. Thank you for accepting our invitation to come to the committee. That's very good. And you have time for a statement, and then we'll turn it over to the committee, which will have questions for either of you in our first hour of the meeting. So over to you, Ms. Warner.
Thank you. Thank you to the committee for inviting me. As a nationally elected representative speaking on behalf of the majority of unionized employees at the Immigration and Refugee Board, I appreciate an opportunity to address this committee. We often express in organized labor our frustration around the lack of consultation that we are afforded as the elected representatives of the workers. So I encourage your committee to continue working with our union beyond today. Some of my history includes 10 years working for the IRB in Vancouver in various positions and divisions in the capacity of registry support staff. I am also the daughter of Chilean asylum seekers, which motivated me to find a career working both with asylum seekers and serving Canadians. Ceiu is a component of the Public Service Alliance of Canada, representing over 18,000 members, including the vast majority of unionized employees at the IRB, IRCC, and Service Canada. Last year, I was elected to my current full-time paid union position as the National Executive Vice President of Ceiu. In my capacity as NEVP, I oversee representation and labor relations. We represent the PM6 decision makers in the RPD and ID divisions of the IRB. I was asked to speak from an organized labor perspective to the committee regarding the appointment process of members, their training, and the manner in which administration deals with complaints about member conduct. Our PM6 decision makers in the RPD are not allowed to comment publicly. So as their elected representative, I will do so for them. I have spent countless hours speaking to our PM6 decision makers in the IRB over the last week and in fact over the last several years. They are going to work every day dealing with the pressures of producing decisions, with a lack of support in the administration of their decision-making, a lack of mentorship, and for the past 2 years, the vast majority of them have not even been properly compensated for their labor thanks to the Phoenix pay system. So to that end, I have to tell you that it's a bit frustrating that the first time that our union is being invited to participate in a venue such as this is as a result of concerns regarding the complaints process, instead of how to better serve the workers at the IRB. In any event, I'll begin by addressing the appointment process of decision makers. On December 15, 2012, Ceiu welcomed the RPD decision makers to our union. Almost immediately, we could see that there would be issues that required our attention. When the decision makers became public sector workers, they were and continued to be paid significantly less than their GIC counterparts by approximately $20,000 a year. They reported and continue to report that they are discouraged from claiming necessary overtime to fulfill their mandates. We know that our members have been providing the IRB with countless hours of uncompensated labor. But beyond this, I've heard this committee discuss both Governor and Council and public sector division maker recruitments and appointments. Ceiu fundamentally believes that all decision makers at the IRB should be public sector workers. GICs are constantly concerned about not being renewed. Instability in the appointment process and the insecurity of the position themselves attracts a narrow field of candidates, often attracting people with similar and privileged backgrounds. Further, in an era where precarious work is on the rise, permanent employment is sought after by qualified candidates. We believe that the new appointments for decision makers should be indeterminate and not term, attracting more skilled candidates. These appointments should be based on merit and experience. There should be no room for political influence through a political process to appoint decision makers. That being said, we do agree with many of the comments that we have heard come before this committee. Decision makers of the board should be reflective of the communities of the people who come before it. So equity staffing of LGBTQ persons, persons with disabilities, and racially visible persons should not only be encouraged, but mandated. Our union would welcome the opportunity to be consulted on developing an equity staffing policy. With regards to the training of decision makers, I have heard from other witnesses about a perceived lack of sensitivity and other training being provided. But having spoken to decision makers across Canada, as well as my own experience working for the board, I'm assured that there is in fact ample training that is being provided, but I would put forward other related matters for your consideration, specifically the need for additional support. Our members have raised the issue of lack of mentorship and pressures to meet unrealistic targets in completing decisions. As well, since 2012, our decision makers have been forced to waste time having to figure out how to make administrative inputs into the electronic database system and lack support by registry staff in preparing files for hearings. In 2012, tribunal officer positions were eliminated. These positions served to prep work for the decision makers. Now that support is no longer available to them, and additional administrative job duties have been added to their already overburdened workloads. The current backlog at the IRB exists for two reasons: irregular border crossings and years of the board being under-resourced. This government is now providing more resources in order to better respect legislative timelines. That being said, it's unfortunate that it's only 2-year funding when it should be more permanent. We believe that without significant changes to the supports put in place for our decision makers, quality decisions will begin to be cast aside in favor of quantity in order to deal with the backlogs. As a union activist, I have a concern about the amount of pressure being placed on my members to produce decisions, but as a Canadian, my concern is on the integrity of fast decisions. We are also concerned about the move to more paper-based hearings in order to render more decisions. This affects the credibility of decision-making and removes some of the humanity out of the asylum process. Regarding the manner in which administration deals with complaints about decision-maker conduct, I'd like to state that, like many of you and many of your witnesses, our union had concerns about the former administration of complaints. That being said, given the number of decision makers and the volume of decisions they are required to render, I'm actually encouraged that there are currently only 2 outstanding complaints to my knowledge before the board. So while there may be a desire to condemn 1 or 2 individuals who have been found to have done wrong, it's unfortunate that the board isn't being acknowledged for the tremendous work that they are accomplishing while under such undue pressure. There is a new investigation process at the IRB, and in our opinion, we should allow this new process to function before we condemn it or attempt to reinvent it. It's management's role to manage, and any outside process would, in our view, politicize what is a management process. I would also ask you to consider the impact of an external and public review for complaints made against decision-maker conduct. We have a real concern that an external system would be abused to discredit either a board decision-maker or the board itself. From a union perspective, we worry that our right to represent will be limited or diminished. We might even argue that our members are being subjected to a process that falls outside the confines of the collective agreement. This would be an overreaching complaint process, providing additional undue pressure on our PM6s that raise concerns of fairness. We believe it would only serve to politicize the complaints process and provide an opportunity to slander the decision makers in the press. Our members are entitled to the right to privacy and due process. At the end of 2018, the IRB will initiate an independent audit of the new complaints policy. Our union is committed to working with the employer on this policy, and we should allow this process to unfold. Why choose now to create a whole separate process when we have one? I would humbly suggest that you would redirect those revenues to fixing Phoenix. Thank you.
Thank you very much. We begin our questions, Ms. Elsa, for 7 minutes.
And thank you very much. I'd like to open with a question from Laverne to Laverne from your previous testimony around the code of conduct. You gave us some ideas of how important a code of conduct would be and some of the challenges around implementing and executing on that. Could you give us a little more detail and remind us of some of the key elements that you gave us at your last testimony?
About codes of conduct is that they're relatively new within the world of
Can we turn it up?
Can you hear me?
Can't quite hear you. Yeah.
What I said initially was that codes of conduct are relatively new within the world of administrative law. That's part of the reason why they've caused a bit of concern. Another thing is that they have been implemented. For example, in Ontario, there has been a statute which requires implementation of codes of conduct, but there's no guidance as to what should be included in them. And there's also no guidance about a complaints process about them. And in fact, if you look at codes of conduct across the country, the ones that do exist, there are very, very few that have an actual complaints process. In a sense, the IRB should be commended for having, kind of set itself into a new field of creating a complaints process. The one exception that's a quite large exception is Quebec, where there is a council that's been around for about 20 or so years, and it's quite an elaborate process. It could be used as a model. So some of the things I'd said in terms of best practices is that we need to have an investigatory panel, and that the ideal process would end with an independent decision maker. So not the chair, but someone else. And the reason I'd said this is twofold. One is that an independent chair avoids the kind of issues that we see with the IRB. The IRB is just a microcosm of what will happen, which is that the public will generally think that the chair of a tribunal is trying to protect its tribunal. And so we can avoid that by having an independent final decision maker. The other thing is that we need to avoid having chairs have any kind of influence on the decision maker itself. So this goes back into deep and long jurisprudence in administrative law, where it's seen as a violation of the independence of a decision maker to have the chair or anyone have an inappropriate influence on the decisions being made.
And if I could ask for Crystal, you to comment on that, because you indicated you're not comfortable with an external board, and if you could give us a little bit of an idea why, and at the same time give us an idea of what the union's role is in a complaint process to support its membership.
No problem. Thank you for the question. Well, as I mentioned, our concern with an external board is that the process would be abused. People would start to use this process to basically member shop for different decision makers, and more importantly, our members are entitled to due process and a right to privacy. We also, with the current process, we've consulted with IRB. We had a national labor management meeting last week, and we had a discussion about the role that the union plays in the internal process. That's an ongoing conversation, but we represent our members well, and we are in a position when the process is internal to the IRB to be able to collaborate with the employer and ensure that our members are receiving the due process that they're entitled to under the collective agreement.
Why would you be precluded from representing your members if it were an external board? And then, Laverne, if you could comment on, would, in your opinion, the due process be jeopardized by an independent board?
We're concerned about our diminishing right to represent, because we don't know what that outside process looks like. We've heard some suggestions here, but without maybe having a more clear idea of what that process would look like, we're basically right now just raising our red flags.
So potentially it's not necessarily the external nature or the independent nature of it. It would be whatever the process structure.
Well, that's part of it, but also the fact that it would be outside of the board. Why would we be taking away the employer's right to manage? That's something, the chairperson of the IRB has a vested interest in his decision makers respecting values and ethics, arguably more than anyone else. So I just don't understand why we would take that right to manage outside of the board.
And Ms. Jacobs? Would that affect management's right, and would it affect the due process of the members involved?
Yeah, I think that this is a very unusual situation because we have decision makers who are part of the public service. This is not something that's normally seen. GIC or OIC appointees are the normal approach. In terms of due process, I mean, it's hard to say because I don't have any examples. I don't think it necessarily has to exclude due process. I think that it's correct to say that it's a matter of shaping that process so that if there is a need or a reason for the union to be involved, the union should be involved. But again, I do want to emphasize how unusual this entire scenario is, simply because we don't usually have individuals who are from the public sector as decision makers.
So in your opinion, should there be two separate processes, one to deal with unionized and one to deal with others?
I'd have to think about that a little bit more carefully, but I think all I can say for now is that without having looked through all of the details, I think it's a matter of considering what the factors are that are problematic and finding out whether or not a process could be shaped that could address those.
Warner, would you suggest perhaps two different processes based on the two different employment structures?
I think I'd have to think about that as well, but I guess I just go back to, to my knowledge, we're on average of 2 founded complaints a year. And so a lot of me is just unclear on why we're having this so much attention.
And how many investigations? You're saying 2 founded, but how many investigations? It's our committee's understanding that the majority of the complaints arise from public servants.
I don't have those numbers in front of me.
And could you give us some idea of what the disciplinary range of consequences are for your membership in this scenario?
I think that just like anything else, our collective agreement provides for disciplinary measures up to and including termination. The employer has the right to manage performance, and we expect them to adhere to the process laid out in the collective agreement. So we're there to defend our members and ensure that the employer is respecting due process.
Thank you very much.
And thank you very much.
Mr. McGuire.
Thank you, Mr. Chair, and thank you as well for your testimony today as well, Ms. Warner. I just wanted to, we just, as my colleague was just talking about the the hiring process, two-pronged hiring process that we have. Can you just explain, for the record, the differences that you see in those two different areas and the reasons for them?
Mm-hmm. So with the PM6 decision makers being public sector workers, especially when they're afforded an opportunity to apply to a permanent position, we feel that widens the scope of candidates that would be applying to those positions. Whereas with GICs, as I mentioned, it's a political process. Often it's individuals with more privileged backgrounds. We would really like to see the board become more reflective of the claimants that are coming before it. And we feel that the avenue towards doing that is through a fair and transparent public sector process.
And can you explain the difference between the exams that you'd have to do for the IRB compared to the exams for similar positions in other departments?
No, I think you'd have to ask the employer that question.
Well, then, do you see any, in your experience, then the Government Council candidates, they're appointed for 3 years for the IRB. Do you see... or can you explain any impact or what impact the length of term? I believe it's 3 years. Can you explain the length of terms and what that has on the decision maker's independence?
Absolutely.
Having that length of time?
Having worked in Vancouver, arguably the most expensive city in Canada, when you're going out to try and appoint people that have families, that have mortgages to pay that are astronomical in cities like Vancouver, trying to find someone who's willing to take a chance on a 2, 1, 3 year mandate, and the amount of stress, I would see that stress in them of being renewed, of constantly talking and being concerned about whether or not they would be reappointed. So we're adding another incredible amount of undue stress on decision makers that are already dealing with really sensitive and challenging work. And it is an incredibly politicized process. We see over the years, I worked there for a decade, and over the years you would see decision makers, GICs, come and go depending on the whims of the government that didn't afford stability to the process.
And in your opinion, then, what would be some of the essential characteristics for good board members?
Well, I've heard the committee talk a lot about considerations around do they have legal backgrounds. I would argue that that's not a necessary requirement. The legislation, familiarity with the legislation, everything else, those things can be trained and learned. But we just want candidates that are qualified, candidates that are able to do the work, that are going to be empathetic towards the claimants that come before them, and that doesn't necessarily mean a legal background.
Thanks. You've answered the next question I was going to ask you about should they require that training? But I guess then, to what extent should these members be familiar, with immigration and refugee law upon being appointed to the board?
I think I would be more concerned with their ability of judgment than I would about because I think those things can be trained.
Mm-hmm. And Ms. Jacobs, could I get a comment from you on that as well? Thank you.
Sure. One thing I would say is that the reason that GIC and OIC appointees emerged historically, one of the reasons is to ensure that there weren't necessarily entrenched views over time. So when we have a 3-year appointment or a 5-year appointment, it's a chance to bring in the new perspectives, perhaps, of not just the political party, because I don't think that that's the aim at all, but of the broader public. So the way that norms change over time can be reflected. So I think that I'm a little bit concerned to hear about the appointments that stem from the public service, just because I am concerned that there may be a greater risk of having entrenched views. I'm sorry, can you hear me?
Not on that one. It disappeared.
Can you hear me?
Okay. Here. Okay, we'll try that again. Thanks.
Yeah. Sorry. So I was saying
here.
I don't know how much you've missed, but or how much I'll go back and say that. And so I'm concerned about public appointments coming from the public sector simply because of the chance of there being entrenched views that are not refreshed over time, as you would have with the appointments process. Another thing that I would say is that while certainly the substantive law can be learned, I think that there are reasons for having members who have a certain amount of expertise, and this might also wax and wane, right? So, for example, right now there's an incredible backlog. It would be useful to have individuals with a high level of expertise brought in. Maybe in other times when there's less of a backlog, we can have people who are trainable and are familiar with legislation more generally. I think the OIC and GIC appointments preserves that, along with the independence, a broader independence for the individuals.
Thank you. We've had several witnesses, I guess, come before us in regards to complaints filed against members for improper conduct during the hearings. And so, Ms. Warner, I wonder if you could just ask or answer the question. I'd like to know how much the union has been involved in those, and what support has the union provided its members facing these complaints.
I think that you can appreciate that I'm in a position of trust with my members. So I wouldn't be in a position to comment on any specific situations, but I will say that our union always ensures that we're vigorously defending the rights of our members. But I wouldn't be in a position to comment on specific situations.
Yeah, I'm not so much asking about a specific situation, but I'm looking at sort of the type of training. Is there a type of training? What help does the union provide its members regarding the conduct of employment under the IRB?
I think this goes back to our ongoing discussions with the employer around mentorship and the need for it. It takes over 6 months to really feel confident in the hearing room, is what we're being told by our members. And so being accompanied once or twice and being job shadowed once or twice, it's not enough. There needs to be longer term mentorship, and also even for the longer serving employees, getting mentorship from newer employees might address some of the concerns that our other witness is speaking to with regards to the entrenched ideas. Sometimes what they're telling me is, maybe that they don't have somebody to bounce ideas off. How do I say something appropriately? How do I ask a question appropriately? And so it goes back to the need for ongoing mentorship.
And have you advocated, as your union advocated for that training and guidelines to be provided to its members?
Yes.
Mm-hmm. Thank you.
A little extra, but not too much extra.
Thank you, Mr. Chair.
On va continuer avec Madame Sans Souci. Merci. Et bienvenue aussi.
We'll continue with Madame Sans Souci and bid her welcome. Thank you. Thank you, Ms. Warner, for your testimony. You told us that your members needed additional support. I would like to hear you on two kinds of training. A number of witnesses appeared before the committee to request that the Commission provide more training on assessing credibility. A number of witnesses also did talk about the new training. I'll say it in English so you know what I'm talking about.
expression, la formation, là, dont l'acronyme est SOGIE.
So that is the gender identity training and sexual harassment training. What is now being followed by your members? Do your members believe the training is sufficient? What kinds of improvement would they like to see to the training? Does the training give them appropriate support so that they can assess the credibility of applicants?
I think that there's always room for improvement, and that's what I'm hearing from our decision makers. Many of them are telling me, in fact, that they do feel that they've had adequate training, that they with the new SOGI guidelines, but also training on central sexual orientation. In fact, they would argue that they have some of the best training in the world. It again goes back to the lack of mentorship, the lack of ongoing support over a period of time to ensure that they're applying their training in an appropriate manner. You asked also about the additional supports that could be required internally. Before 2012, with the introduction of the PACISA legislation, our decision makers had tribunal officers that would assist in preparing files for them, assisting with analysis and research. The clerks, that's where I started at the IRB, we would do all the administrative tasks for them. In today's world, the decision makers aren't spending enough of their time, in my opinion, doing decisions and hearings. Instead, they're spending too much of their time prepping files, trying to figure out an ever-changing computer system to input information. This is work that could be done by registry support staff, and I've never understood why this isn't something that's being lumped onto their already over tax schedules. The IRB actually provides their training internationally, and some of the decision makers I spoke to this week have traveled to other countries to assist other countries in their training. But I have listened to suggestions from other witnesses and have already and will continue to raise questions to the employer regarding training for re-traumatization of asylum seekers, or the need for ongoing training on accessing credibility and avoiding bias. But from what I am seeing already, it does sound that they are receiving the appropriate forms of training. Again, like I said, it's going back to receiving the mentorship and the guidance and supports over time to be applying it appropriately in the courtroom.
Fait que, si je comprends bien ce que vous nous dites,
if I understand correctly, what you're saying is that above and beyond the kinds of training provided, what people need, and it seems you believe that's the solution, what people need is ongoing support, continuing support, rather than training at regular intervals. Other witnesses talked to us about additional training as well, be it the kind of training you need to have after a complaint or after an annual performance review. However, it seems that frequently the training that follows is inadequate. So are you saying that above and beyond those kinds of training, what's needed is ongoing support? I'd like to understand what you mean tangibly. What form would that take, really?
Do need that ongoing support, and they need it from more experienced decision makers. I would argue that more experienced decision makers also need it from some of the newer decision makers. I think we also have to consider, too, the stress that our decision makers are currently working under. We've been under-resourced for years. So their targets for decision making continue to increase to the point that they're stressed out when they're in their hearing rooms. They don't have enough time to render decisions. They're not given days where they can, sit down and write a decision. So they're being pressured to do hearings in the courtroom and make decisions in the hearing instead of doing a written decision after. And I think all of that's lending towards the current environment, which to me simply goes back to the fact that they're under-resourced.
mais je veux comprendre.
I want to understand properly, because this is clear to you in your mind. You mentioned it. It already existed some years ago, but I'd like to understand what you mean when you talk about mentorship exactly. You say that mentorship would be a better way of providing tools than regular training, but how would it work? Is every employee twinned with someone? someone who can give some feedback on decisions? I don't understand how this would work in practical terms for decision makers.
I think that would require a lot of extensive consultation with the employees. And I know from speaking to them this week, they have a lot of ideas of what that would look like. But that's not something that I think I'm in a position to lay out.
OK, je comprends bien. On le voit.
I see. We are seeing that budgets are more and more geared to short-term hirings. Is that approach having an impact on your members, on training, and on the significance of or scope of the cases they have to deal with when employees are only there for a short time?
Not just at the ARB, but I think across the public sector, we've seen a decline in mental health of employees as a result of being constantly asked to do more with less. Being underfunded at the IRB for years has affected the entire board. The amount of stress and the amount of pressure to produce is no doubt affecting people's health, and it's affecting the quality of their work. And so we're being pressured to move towards faster decisions and more paper-based processes, instead of giving the asylum process the respect it's due by properly resourcing it. So we've been understaffed for years at all levels, even 2-year funding, a decision maker, it's going to take at least 6 months to start feeling really confident in that boardroom. So between trying to recruit them, train them, the money is almost gone. It has to be longer-term funding.
Thank you, Ms. Warner. Merci, Madame Sans Souci. Mr. Whalen.
Thank you very much, Mr. Chair, and thank you for coming, Ms. Warner. You asked at the outset why you are here, and I will say, for at least from the reason I voted in favor of doing this study was because the IRB had come into disrepute or was seen to be coming into disrepute as a result of certain very high-profile media stories about the conduct of members. And so hopefully our recommendations around appointments, training, and the complaints process will help that. But your testimony is very helpful today, so thank you for coming. As is yours, Ms. Jacobs. And I'll start with you, Ms. Jacobs. There seems to be a disconnect in some of the testimony we've been hearing from witnesses around what they perceive to be the motivations or the primary role of the chair. Ms. Jacobs, do you think that the Supreme Court Chief Richard Wagner is inherently there to protect the other judges, or do you think that his role is more there to protect the administration of justice?
I think that his role is both. So I think that if we're talking
Sorry, you're saying that you believe that the Chief Justice is there to protect the judges?
Sorry, no, the role is both. So you'd asked whether it is to protect the, if I understood it, was to protect the public?
No, protect the judges or to protect the administration of justice.
Oh, okay, sorry. Definitely to protect the administration of justice.
Okay, so then with respect to Mr. Adderman, why do you believe that his role is to protect the IRB members and not to protect the administration of justice?
I don't think I said that his role is to protect the tribunal.
Well,
members.
you'd actually said in your answer to Ms. Alislev's question that the public would perceive that he is inherently there to protect the members.
Exactly, that's what I said. I said that the public.
So is he
will
there to protect the other decision makers or to protect the administration of justice within his department?
I don't think it's that easy, right? So I think that he will always be perceived as being there to protect the integrity of the tribunal. So and this is not just the IRB, this is any tribunal chair, will always be perceived as having an interest in making the tribunal look its best. That's what I was trying to say.
Well, I don't think that's the same as what you'd said earlier, and maybe I'm glad you've been able to clarify, because protecting the integrity of the tribunal would mean to get rid of bad members. And I think that he would understand that also to be his role, not to protect the members. So maybe you erringly said that earlier. On a similar note, Ms. Warner, I'm trying to rationalize in my head the role of the a potentially an independence complaint process with, which has been suggested by many of the witnesses before our committee, and whether or not that jives with the potential for public servant decision makers on the board. And it seems to me that there's an inherent disconnect between what most of the witnesses have suggested and your testimony. So do you view that the independent adjudicative process on complaints is inherently at odds with a labor management complaints regime that currently exists? Or do you think that they can be rationalized?
I have concerns about it, but I think without more information on what that process would look like, I couldn't really comment further.
Would it simply be easier to have members who are simply not public servants and have more clerks, as you've suggested, who would be unionized and we managed as labor by the management of the chair of the IRB? Because it just seems that that previous system wouldn't run into these problems.
I would disagree with that. I don't think that that would be simpler. I think that the way that the board's been conducting its affairs is fair. There's any system is going to have problems. There's always going to be individuals that are not suited for their positions.
Sure, but I'm just wondering whether the regime is wrong, because you're referring to the relationship between the chair and the members of the panels as being an employer-employee relationship or a manager and labor relationship. When I view the role of the chair in managing the administration of justice within the department, it's clearly not. The members are not the employees of the chair. They're independent adjudicators. And so it seems to me that it's completely at odds. The view you expressed of the relationship between the chair is not my understanding. Maybe we'll get to that with Ms. Adderman later, but do you have anything to comment on that? Because there seems to be a disconnect in the role.
No.
With respect to the staffing at the IRB, can you more broadly describe the role of the clerks? We've heard a lot about the role of the members. It seems to me that maybe one of the problems we're running into relates to the staffing at the clerk level. And you're the first person to have raised that before us. So if you could speak more broadly to that, it'd be very helpful.
Yeah, I think that it goes back to being under-resourced. As I mentioned before, we used to have different positions that no longer exist at the board that provided an extra layer of support to our decision makers. Those positions were eliminated in 2012 with the new legislation. And so as a result of that, like I mentioned, our decision makers are spending too much time doing administrative work that could be done by registry support staff.
It's almost as if the members are both their own clerks and the decision maker.
Yeah, they would say
given
that.
two jobs. Okay. And Ms. Jacobs, you've been a strong advocate for an independent complaints process for the members. You've been, very helpful in that. I'm not sure if I'm entirely convinced yet, but you've made some really good arguments. How do you feel about the role that Ms. Warner describes as the lower level adjudicators being represented by organized labor, and how does that conflict with requirement for an independent adjudicator? And how does Quebec deal with this? Do you have any organized adjudicators, and how does Quebec handle that problem?
I can't comment on how Quebec deals with that problem, so I won't deal with that. I think Professor Uhl would have been a better witness for that. In terms of having adjudicators who are part of the public service, what I'll say is that they are not. What I've been talking about is having more GIC appointees, or respecting the independence of GIC appointees. So I'm not sure that, if your question is whether or not there's a conflict there, I think that Professor Uhl last day went through quite succinctly talking about Matsqui and the other cases, showing that there is an argument for a higher level of independence. Yet, of course, the fullest level of independence would come from GIC appointees. There seem to be many different factors that could have an impact on the work of the decision makers who are public servants, and that seems to be a bit concerning.
Thank you very much, Ms. Jacobs. And one final quick question to Ms. Warner, and see if I can get this right. One of the ways in which the GIC appointments manage poor performance by their members is that they're just not reappointed. Would it be possible within the labor relations regime that exists now to have an up-and-out option for the initial appointments for unionized members? So they would originally come in for a 3-year contract, and then if they don't work out, they're gone. Would that work with your union?
Are you asking me if there could be an alternative way to fire my members easier?
Well, maybe going forward for new members who join, could they join part-time or in a way? And that's what I am asking.
Okay. So we have a collective agreement that provides disciplinary measures, and the employer has the right to exercise those disciplinary measures up to and including terminations. They have the right to manage performance, and they're doing that. We don't see an issue with the way that things are currently being handled. If the employer does their job and the members are
Thank you, Ms. Warner. Yeah, you got the point up. Mr. McGuire, back to you.
Thank you, Mr. Chair, and pick up on that as well. I just wanted to check with you in regards to your opinion on the essential characteristics of those good board members. We referred to that before, but the backgrounds of appointees have been discussed by several witnesses, as I pointed out. Some of them are looking at having better substantive knowledge of the refugee law that I talked about earlier, while the others are highlighting the importance of members having personal characteristics, but just about fair decision-making procedures. And so I'm just wondering if you, and you referred to this earlier, about the ability to identify and understand people as opposed to having a specific training in law. And I'm assuming that Ms. Warner, I'll ask you first, in regards to the compassion that's involved in the process, or is that something that should come into it, or is it a definitive type of understanding that's required? And if it's not in law, is it in other areas of expertise, such as psychology or some of those areas?
I think we would really welcome more diverse backgrounds at the board. I can only speak from my experience, and I've seen lawyers succeed at being decision makers, and I've seen them not succeed. And I've also seen persons with a variety of different backgrounds and experience in human rights do exceptional jobs at the board. So I don't think there is any one size fits all.
And so we've had witnesses tell us, too, that there's complaints mechanisms. Some of them aren't well suited to resolving the problems of decision-maker subjectivity. And so I'm just wondering if you feel that there could be an interference with the deference normally shown to first-instance decision-makers in some of these cases.
I think this goes back to our concerns, too, around moving towards paper processes. Having the in-person hearings at the first, it's going to allow the decision makers to assess the credibility of the claimants that are coming before them. But I think that's really all I can comment with regards to that.
And Ms. Jacobs, would you have any comment on either of the questions that I've just asked?
So with respect to the first question, I think that some of the qualities that are important are an ability to be fair, an ability to be empathetic, an ability to check biases, including implicit and attitudinal biases, and certainly a familiarity and ability to work with statutory interpretation. Part of fairness would include credibility assessments, I would say. Sorry, could you repeat the second question?
Well, it was more looking at the interference with the deference normally shown on a first instance decision maker's basis, and that comes from the fact that we've had the complaints mechanisms have been identified as not always being well suited for resolving the problem of decision maker subjectivity.
Right. I think that I'd want to think about that a little bit more, but yeah, I don't have a comment on that.
Yep, thank you. Most of the complaint system that's created internally is created internally with the IRB, whereas justice of the peace are largely regulated under the Justice of the Peace Act. So do you think that the federal government should make amendments to the Immigration and Refugee Protection Act, I guess at that point, to institute a proper complaints process? Or does it make sense to be handled internally? And that's for you, Ms. Jacobs.
I think that the process that they have implemented can be modified so that it is it has the additional features that I've mentioned, such as an independent decision maker that's final. I mean, I suppose we could go the alternate route of creating an entire new statute, but we need to look at, why there was a statutory basis for the Justices of the Peace Act. Traditionally, within administrative law, guidelines of this nature can be made by the board, and I think that the board has worked within its own jurisdiction. So there's no legal issue with what it's done.
Thank you. As my colleague across the way pointed out, this process, our hearing here, our process began because of complaints that we received in regards to some of the members on the committees. So do you think that
very
the
quickly
process for removing, thanks, Mr. Chairman, the process for removing an IRB member who's under the Public Service Act is too difficult or lenient?
I think that actually I haven't looked at the Public Service Act. Under IRPA, I've looked at how an individual can be removed, so perhaps I'll save you time.
Okay.
Thank you. I need to go to Mr. Tabera.
Thank you, Mr. Chair. Ms. Warner, you mentioned that when you're talking to my colleagues on this side of the committee, that the IRB was underfunded and understaffed. With the added $74 million to the IRB, do you think that will make a difference in processing asylum claims, etc.? And then I'll get into another question right after that.
Yes, I absolutely do. But as I mentioned, because it's only 2-year funding, it's too short term.
It's hard for you to plan, so you need more funding.
We also don't know what's coming with things that are occurring south of the border. It's hard to predict the necessary resources that we're going to require.
Okay. I just want to, because I'm probably one of the last person that will be asking a question, I wanted to ask to both of the witnesses, just to kind of wrap up, because this is one of I think our last meetings or the last meeting. Some of your suggestions that you can give to the committee in terms of complaints, in terms of training, and appointments. In those 3 streams, we've heard a lot of suggestions. I just want you to maybe just come together and just maybe give us suggestions on those 3 areas so that we can kind of wrap up this study.
I think that I would have a lot to say on all of those areas. Is it possible for me to provide written submissions to the committee?
Yeah, you can provide written submissions, and if you have something quick that you want to say, you're more than welcome to. But I'll refer to Ms. Jacobs.
Yeah. So with respect to complaints, I think that the process that has been put in place is an improvement over the one that was there before. I think an ideal process would have a final decision maker who's independent. I think that it's possible to phase that in over time, so it doesn't have to be changed right away. But that's my main recommendations, and perhaps to look at that. With respect to training, I think that it's important to emphasize training around credibility assessment, as that's arisen quite a bit in the news stories, etc. I think that training around implicit bias, etc., is also important. And I think that anonymizing conduct complaints so that they can be used as training tools in a collective manner for the board would be useful as well. In terms of appointments, I think that appointments are fundamental and really the starting point. It's important to have merit-based appointments to really examine the appointees that are coming through in terms of both their ability to handle adjudication, hearings, and in terms of their ability to know the law or their potential to learn the law if they are not at that stage. And as I mentioned earlier, I think it's important that to keep in mind that sometimes the nature of the appointments might vary. So, I think that sometimes you'll need people who have more expertise at a certain point in time, like now with backlogs, and perhaps maybe in other points in time you'll have a need for people with more of an ability to manage hearings. I also want to say that, I think that the IRB is generally doing a good job. I've heard others say this as well, and I agree, and that it is really the behavior of a few particular individuals that's, challenging, and that the discrepancy rates in approvals is also somewhat concerning.
I would agree with you that needs to be more resources put in place so that there's more ability to manage hearings and to be specialized and not kind of bogged down by various other requirements that are needed. I just wanted to ask Ms. Warner if you wanted to elaborate on that, on how that's that extra work is hindering kind of the employees, some of their work that they're trying to do.
Well, it's hindering the board's ability to retain its employees because the funding, is sporadic and it's never long term. So we're not able to attract, we're not able to post for permanent positions, and then we're not able to retain staff because we don't know if the funding will be there the following year. So the need for the ongoing A-based funding is vital.
Thank you, Ms. Warner. Ms. Rempel for 5 minutes.
Thank you. Ms. Warner, has the workload of your members significantly increased in the last year?
Absolutely.
Ballpark a percentage?
I couldn't give you that information.
Okay. There's two ways to look at increases in workload. One is, do we put more resources in place? The other, we look at demand on services, right? How many cases are you anticipating reviewing over the next year with regard to claims that have been filed by people who have entered Canada illegally from the United States and then subsequently made an asylum claim?
I think you'd have to ask the employer about irregular border crossings.
Okay, but has that particular issue put a significant demand on processing?
Yes, of course.
Would you say that the increase in resources that you're requesting can correlate to the fact that there has been a significant increase in asylum claims coming through that particular channel?
Yeah, but I would also argue that we've been under-resourced for years.
Okay.
And so we've seen pressure being put on the decision makers to increase their stats of completed decisions even prior to last year.
Okay, so certainly, would you agree with the point that this has exacerbated the situation?
I don't know if I would say exacerbated the situation, but I think the bottom line is there was a need for the additional funding, and the funding needs to be longer term.
Sure. So, but just to clarify the point that I'm trying to make, last year we had over 20,000 people cross the border illegally from the United States into Canada. Many of them made asylum claims. So, I know that your staff have admirably been working really hard to clear a lot of backlogs. But just to clarify, you don't know if it has exacerbated it. Do you think it's fair to say that an additional 20,000 cases coming via this channel has perhaps led to an increase in workload?
I would have liked to have seen the funding come before this last year.
Okay.
I think the IRB is going to be able to do the job. They're being better funded now. Hopefully this government will make a decision to make that funding longer term, but they're going to be able to deliver now.
So when you say deliver now, there have been news reports that say that the IRB has sort of just given up on the 2-year legislated timeline. When you say do the job, over what time period?
So I struggle with news reports saying that they've given up. They absolutely have done anything but given up. In fact, they're working harder than ever. And now that they're being provided with the funding to be able to meet the increased demand on the board.
So let's say somebody illegally crosses the border today from the U.S. into Canada. And I know every case is different, but what would the average time be for that person's case to be processed?
You'd have to ask that question of the IRB.
Okay, so just in terms of some of the comments that you just made on being able to get that processed, it's qualified by the fact that you don't have that information in front of you. Is that correct?
I'm qualifying my comments based on the discussions that I've had with PM6s across the country.
Okay. So what I'm trying to get at, though, as a legislator is, how we allocate resources. And, certainly we want to ensure, to be clear, that the IRB is functioning and doing its job quickly, because it's important that when someone makes an asylum claim that we're processing that, both in fairness to the applicant, but also if somebody doesn't have a valid reason to be in Canada, they shouldn't be. But I'm just curious, though, within your staff, you've talked about you think that they can get the job done. Have you had any conversations about what the increased resources that you're asking for would lead in terms of efficiencies and processing time? So you've made requests for more funding. In terms of metric, based on the current volumes coming in across the border, how is that going to, by metric, how much is that going to reduce the processing time? Because we've heard
Those aren't
reports from
stats that I
11
track.
years to...
Those aren't stats that I track.
Okay.
So I wouldn't be able to answer that question.
Okay. So it's just it's a request for funding without, it's not being tied to necessarily reduced times as the metric.
The union's not the one putting the request for funding in before
Okay.
the government.
Okay, thank you for clarifying that. In terms of actual processes or metrics, and I know the union is advocating for positive working conditions and whatnot. Do you think that the increase in the load that's come through has led to what has it done to the workplace morale right now? Because I'm sure it's pretty heavy in there.
About 10 seconds.
And yeah, thank you for asking that question. We're working with the employer on addressing the mental health of the workers, which is our number one priority at this time.
Thank you.
Thank you very much. Mr. Secretary, I've got time for a couple minutes, if you'd like it.
Thank you, and I'm going to be directing my questions to Ms. Warner. I would imagine your members are quite proud of the work that they did with the resettlement of the Syrian refugees over the last 2 years. Is that accurate to say?
Yes, they are.
Yes, they are. And was there increased workload at that time?
Yes, of course.
And how do they view that? How do they undertake that project, and what legacy does that leave for your members?
I spoke earlier to the fact that our members have provided the IRB with countless hours of uncompensated labor, and I think that speaks to their commitment to the work that they do. They should be compensated for that time. We have brilliant staff at the IRB. We have peoples with master's degrees in CR4 levels that speak multiple languages, and they stay at the board because of the level of dedication that they have in the service that they're providing to Canadians and future Canadians. I've never seen anything like it, actually. So they're incredibly proud of the work they do. Thank you for the question.
And there are times in Canada where we'll have increased amount of work. I think for your members particularly, I think immigration is not static in terms of a number. It evolves, and the last couple of years I think we've had those demands. Do your members look at this as part of a grander vision of this country as opposed to a chore? Because I think that from what I've seen and the members I've spoken to who are part of your union, I think they were extremely motivated, and in fact they were almost fighting to fit in some of those roles during the Syrian situation. So is that something that I think you as a union and you as your membership looks towards immigration as something that evolves, and there are times when additional resources may be put in?
Of course. Our members have the same values and principles that our union does. We believe that Canada is a compassionate country. We welcome the diversity. And in fact, I'd go so far to say that our union would like to see this government suspend the Safe Third Country Agreement.
Thank you very much.
Thank you.
Thank you. Thank you to both witnesses. We need to end the first panel here. Thank you for coming back, Ms. Jacobs. That's very helpful. And thank you, Ms. Warner, for joining us today. We'll take a brief pause as we turn over to the next panel. I think we're going to call this meeting back to order. I know that some members will be joining us in just a second. We do have quorum, however. I want to thank Mr. Adamman, the acting chair of the IRB, for coming back to our committee again on this study, as well as bringing Mr. Kipling, the Director General for Policy Planning and Corporate Affairs Branch. Thank you. And we're delighted to have a statement from you first, and then we'll move to questioning.
Merci, Monsieur le Président. J'ai suivi.
Thank you, Mr. Chairman. I have carefully followed the testimony of those who appeared before the committee. Some of those statements raised important concerns. I will, in my remarks, speak only about those concerns. First of all, I'd like to point out that the IRB's decision to review the complaint processing mechanisms regarding commissioners was taken in 2016. Reports in the media which led to the study go back to the end of 2017. In other words, the new process, so the new complaints process has not been formulated in response to negative press. Clearly, media reports were troubling, and anyone who read them would have been quite rightly concerned. But the IRB, well before those reports were published, had recognized the need to review the complaints process in order to be more efficient, and therefore established measures that included consultations with stakeholders.
Complaints process. A number of witnesses have suggested that having the chairperson decide on complaints puts him or her in a conflict of interest. In my respectful view, this reflects a misunderstanding of the role of the chair and his or her accountability to Parliament. In fact, it seems to presume that the chair actually has an interest in covering up misconduct. Both Ron Ellis and Professor Flaherty point out that as the head of the tribunal, the chairperson's paramount interests are in preserving the integrity of the adjudicative system and the reputation of the board. And it's exactly for that reason that the complaints process was changed, so that the chair now deals directly with all complaints. Third, some witnesses suggested that the complaints process is an appropriate means to challenge the substance of a member's decision, not just their conduct. Much reference was made to variances in acceptance rates. The suggestion seemed to be that members say no too often and that something should be done about that, possibly through the complaints process. In my view, this approach is completely at odds with one of the most basic principles of the rule of law. Adjudicators are supposed to decide cases on the evidence before them and on the law and on nothing else. Once we start trying to engineer outcomes by pressuring adjudicators, such as through the threat of complaints, the rule of law is undermined. The complaints process is to be used to address allegations that relate to conduct of decision makers, but not to challenge the substance of what they decide. That's a matter for appeal tribunals and for the courts. I would urge this committee to bear this crucial distinction in mind. Fourth, a number of witnesses suggested that expertise in immigration and refugee law should be a precondition to appointment as a member at the IRB. In our experience, having a background in immigration and refugee law is not nearly as valid a predictor of success as having the competencies that make a good adjudicator, and those are empathy, cultural sensitivity, reasoning skills, writing skills, and organizational skills. We teach new members the law, and in fact, teaching the law is the easy part. Teaching members how to run a hearing fairly and efficiently and with respect and with sensitivity are all much, much harder. And that's why we try to select people at the outset who have the right competencies, as opposed to looking for people who have a background in the areas of law that the board deals with. In fact, if we were to narrow the pool to those solely with a background in immigration and refugee law, this would seriously hamper our ability to recruit qualified people at a time when we're under immense pressure to find a large number of additional decision makers. Finally, the approach to selection that we take is one which aligns with this government's approach, which is a focus on identifying highly qualified candidates who reflect Canada's linguistic, regional, gender, and employment equity diversity. Last, I would like to make it clear that as an accountable tribunal, this board is committed to continuous improvement. And I'd like to give you an example which we're working on at the moment. And that is that we're in the process of evaluating, 1 year in, our use of the sexual orientation, gender identity, and expression guidelines. We're looking at how the guidelines have been applied to date. We're going to share our analysis with external experts, and we're going to seek their advice as to how we move forward to ensure the effective application of these new guidelines. Thank you.
Thank you very, very much. I'm going to turn to Mr. Nandasangri for the first round, 7 minutes.
Thank you, Mr. Chair, and Mr. Otterman and Mr. Kipling. Welcome back. I just want to, before I go into questions, I just want to bring something to the committee's attention, and I do want to, I usually don't like to bring in matters during testimony, but I do want to bring it at this time because it does reference Mr. Otterman's letter of April 23rd, 2018, wherein a request that was made by this committee for a copy of the interim report of Mr. Neil Yates was referred back to us as the IRB being unable to provide same to us. So I do want to, at this point, seek, I don't know if I need to seek consent, Mr. Chair, or just move a motion.
You can move a motion.
Move a motion that the requested documents be provided by the department, because I believe they are the ones that had mandated the study. So I move that the request of April 17, 2018 now be directed to the department for response.
Thank you. Just to clarify for the committee's information, the committee did pass a motion that did request a document from the IRB. The IRB has respectfully said that they don't feel it's their document to give. We have a number of options when that happens. One is to simply agree with the requested person's declining to give us the document. The second is we could negotiate with them, or the third is we could compel it. And I would say this is in the second category, which is following what they are saying and saying that rather than the IRB releasing the document, it would be the IRCC that would release the document. So the motion now is actually asking the IRCC to provide us with the document that was requested on motion, duly approved by this committee. That's understood by everybody? Seeing no discussion, all in favor? Any opposed? That's carried. All right, now you can go on with your...
So how long do I have, Mr. Chair?
You have about 4.5 minutes.
Okay. So, Mr. Admin, I want to just make one thing absolutely clear. The IRB is, in many ways, the envy of the world. It is, you've set very high standards in terms of adjudication, and from lawyers to other stakeholders that I have personally been able to speak to over the past number of years, IRB does stand out as an incredible body that has done a great deal of work. And you, in your last encounter here, had indicated that over 435,144 IRB decisions have been made since 2009, and that's remarkable. Where I think we're kind of stuck is that there is an appearance, and it's not an actual conflict, but there is an appearance of conflict. There's an appearance that the chairperson undertaking the investigation, may have some interest. And while I acknowledge what you said earlier today, I do think we need to find some opportunity to ensure that the IRB continues to be unimpeachable in terms of its adjudication. So what can you offer us today that will allow you to continue the work that you do without putting a strenuous layer of adjudication for complaints, but still be able to reassure Canadians of the independence of the board, as well as the investigative process, which I think are two different things here?
Well, I guess what I would say in response to that is just to refer you back once again to the remarks that I made initially. The media stories quite rightly attracted a lot of scrutiny and
Mr. Adams, I want to go away from the media stories.
Okay.
Because I'm looking at now strictly from a process perspective. So, right? So I think just not to get hung up on the media assertions, but just to look at it from a strict process point of view. There's a complaint against one of your adjudicators. It's brought to by either a claimant or a lawyer. And presumably it's after the fact of the decision. The problem is that complaint comes to your office, and that may or may not be a problem. But that complaint comes to your office, and you basically oversee the process of that complaint through an independent, body. So all I'm asking is there any other way? Can we put an advisory committee in place? Can we put some other measure in place where there is another layer that can buffer, your office? And the process, so that there is at least an appearance of an increased level of independence.
I don't think that sort of having the matters dealt with by the chair's office poses an administrative burden. I think the problem has been the perception problem, which you point to, is a problem which we've tried to rectify by changing the process and making the chair directly accountable. Could the chair benefit from the advice of external disinterested parties, perhaps, who review the complaint with the chairperson? That would certainly be a possibility. What I would urge in that regard is that if that's a direction which this committee wants to pursue, then I would suggest to you that it's not, if you're looking for a completely impartial view on these things, then those external advisors should be people who have no stake in the game. That's to say, they shouldn't be people from the immigration and refugee bar, because those people have an interest in the outcomes. That might be an option which you would want to pursue. But I would urge you also to bear in mind, the cost and time and complexity associated with judicializing this process. To my knowledge, Canadian Judicial Council's had referrals to external inquiry bodies. It's done it, I think, 14 times since 1971. I haven't been privy to those, but I followed this in the media, and some of those inquiries were extensive, protracted, and involved large numbers of lawyers.
Mr. Ahmed, that's what I'm trying to avoid, right? Because I do think another elaborate process may not serve as well, but I do think it's important that we address the legitimate concerns that have been brought to us by a number of people, and that's really not a reflection on you. It's really the appearance that people have that the adjudication is still in the same office. So I think a way to buffer that.
I need you to end there. Thank you very much. You'll get a chance to add as other questions asked. Ms. Rempel.
Mr. Chair. So thank you for coming again. Thank you for the work that your organization is doing. I just wanted some clarity on some points that certain witnesses had raised. One was with regard to the complaint process and a list of possible outcomes of a complaint. This was raised a few times. So other quasi-judicial board, like the Justice of the Peace, have a very clear list on outcomes of complaints. Is making this outcome list public something that you're looking at committing to?
Well, there's a couple of things I would say in response to that. One is that the board's response to any given complaint is a function of the facts of the case. So, and in the large majority of instances, they are, in our experience, they're one-off instances where a member behaves in a disrespectful or rude way to a complainant, and those are addressed through things like training, through reprimands, through apologies. Serious matters like removal from office. In the case of governor and council appointees, the governor and council appoints, and it's the governor and council who terminates or removes a GIC appointee from office. So that's not a power which the board has. There are provisions in the Act which deal specifically with that. They're complex and they're fairly cumbersome. On the public service side, the chairperson, as the deputy head of the organization, has the powers to remove a public service decision maker, but it's in accordance with, following due process, collective agreements, and the statutory provisions around that.
Is there, I'm just for time, would you say that there is consistency or a framework that's applied in terms of outcomes of complaints? So similar types of crimes, if you will, would have similar types of punishments, if you will. I guess what I'm trying to say is I'm not sure how you enforce a standard of behavior if it's not clear what the reprimand would be when there are instances that have been deemed to be worthy of the same.
Well, I don't think... I think it would be practically very difficult to sort of create a tariff or a grid which says, this particular misbehavior attracts this particular sanction. It's a function, because it's a function of the facts of any given case, right?
Yeah, but one would say, especially the case that precipitated this, where there's certainly by media reports a fairly egregious act of what could even be described as misogyny that there would be some sort of clearly articulated outcome ahead of time. I guess what I'm trying to get at is I don't understand how we can enforce a code of behavioral conduct if the outcomes of complaints aren't clear to those who work under them.
Right. So I think, it's a fair criticism to say there was a lack of transparency around this, and not just in terms of the way the complaints were processed, but also in their outcomes. And I think that the effective remedy for addressing that is actually to centralize it, which is what we've done, so that there's one decision-making body which is dealing with all complaints, and the consistency will flow from that.
Again, too, I'm looking at ways to my colleague's point. We don't want a giant cumbersome bureaucracy, nor do we want a kangaroo court, or nor do we want, vexatious complaints. But don't you think that sort of even if it's a high level framework that suggests what the potential outcomes could be for a successful complaints process, that would actually help clarify and reduce some of these problems, right? I'm thinking about a case that's been, if a complaint goes through and then there's subsequent media or something where somebody feels like justice hasn't been served, right? That having that transparency up front both promotes appropriate behavior, but also, prevents this back and forth and having us back at this committee in 2 years, that sort of a thing. I just was wondering if you wanted to comment on that, because this has come up a lot with our witness testimony.
Well,
so.
It's not difficult for us to sort of spell out the range of possible sanctions. But what the range of possible sanctions is in relation to any given case is the kind of thing which you can't and shouldn't do in advance, because that's essentially prejudging it.
Of course.
So and I think this is actually known to members that the sanctions can range from a reprimand, training, removal from the hearing room, ultimately to termination.
But to clarify, right now that range of possible outcomes isn't something that's publicized in a coherent way, correct?
No, that's a fair comment. And I think the reason
that's more what I'm trying to get at is that I'm not asking for prejudgment. That's a fair comment, but I think part of the issue is that there's a lack of clarity on, like, what's the point in putting forward a complaint? I don't know what the outcome is going to be. So is that something that potentially you think would be a good idea, like just clarifying the range of potential outcomes?
It's not a problem whatsoever for us to amend the protocol to spell out what the possible range of sanctions is.
Okay.
What would be a problem would be to sort of try to match those to particular behaviors, because then you lose sight of the facts.
Understood. I guess just following on to your comment, do you think that the range of potential outcomes are adequate right now to enforce the behavioral conduct that you'd like to see out of? Okay. So for stakeholders that have said no, what would your pushback be?
Well, I think that the problem is, and I quite frankly have indicated to this committee, are the failings of this organization in the past to do that in a consistent, transparent, and logical way, and that's why
very briefly. And I'm sorry to cut you off, just for time. With regard to the case backlog that you're seeing right now and potential complaints, do you think that the large backlog that you're seeing will have an impact on asylum seekers' ability to recall details that will determine the outcome of their future hearing?
It is a concern. It's a concern, for example, which we addressed. We have the Legacy Task Force, which was dealing with those cases that we couldn't, from the prior to the amendments to the statute. So we had a number of cases which we've been tackling and making quite a lot of progress on, which date back a number of years. So there's some people who are waiting up to 8 years to have their refugee claim heard. When we constituted that task force, we actually trained members specifically on the issue of credibility assessment in light of the fact that these events are now sort of receding back in time. But it's always the case in any adjudicative system that the fresher the evidence is, the easier it is to make a decision.
Thank you, Mr. Adderman. Ms. Kwan for 7 minutes.
Thank you very much, Mr. Chair, and thank you, as well to our representatives for coming back to the committee. I know that in the correspondence that you have sent to us, you highlighted 3 items, and particularly I just want to touch on a couple of the items. One is the perspective that for a complaint that has been lodged, and because the board member in question has left the organization, and the perspective back then was to say that we were no longer able to pursue the complaint to its finish. And in your correspondence, you now write upon reflection that there might be a way to do so, and in fact, you would pursue that. So I wonder, when you have that process outlined within your organization, once you have fleshed out how you would exactly do that, can you bring that information back to this committee for our information as well? I'm particularly interested in this because I think it is important to finish a complaint to the end and to ensure that the complainant have a resolution ultimately.
Right. So, you know, and I just need to be clear on that point. Once a member has left the organization, we have no power to sanction that member. We do have a power, and this is the point that I think we sort of changed our approach on, is that, you know, even if we can't sanction that member, we can make a determination as to whether or not there was misconduct. And the value in doing that, I think, are the institutional lessons that can be drawn from it, as well as closure for the complainant. So, you know, we would come back to you, we'd certainly be happy to come back to you with, indicate how the amended protocol addresses that.
I would appreciate it. I do think that it is important for, again, a complaint to come to its finish. Now, on another point that you reference in your correspondence is the issue around training. Now, through our committee discussion, witnesses have come forward to respond to the notion that when a complaint has been lodged and found to be founded, and that training is required for that particular member. I asked you the question at that time to say, how do you determine and assess whether or not that individual's training or additional requirements to go through a process is successful? And your response was that it would be evaluated in the year-end evaluation. Some of the witnesses said that that's not good enough, and in fact you need to check back to make sure that the additional training that was required of a person who's been sanctioned has been incorporated appropriately. And so to that end, I wonder if you could comment on that, to ensure, the purpose here is to ensure that where a complaint has been founded, a person's been required, for example, to go through additional training, that training has the necessary effect that I think we desire. Doing it at a year-end evaluation is one component, but also following through after the training has been administered to ensure that it has been effective is equally important. So I wonder whether or not you could comment on that aspect of it.
Well, yeah, like in any organization, you know, we have a formal process for evaluating. It's done on an annual basis. It's cyclical, but like any other organization, you know, there are managers who sort of are keeping an eye on the people who report to them on a daily basis. That's done informally. And, you know, if there's a problem with a particular member, you know, the member's manager is cognizant of that. The member's manager is involved in things like designing what specific training they're required, and the member's manager on a daily basis is watching how they're doing. Right? It's written up at the end of the year in a formal evaluation.
Sorry, I'm not talking about a daily performance. And yes, even, you know, as an employer, for example, right? If you have a situation where you have a person that you have indicated there are issues, and let's say a complaint comes forward and the complaint has been investigated and found and to have been founded to be valid, the person is required to go through additional training. You would want to have a way to assess that additional training has been effective, not just in an informal way, but in a formal way. And that's important. Likewise, even just aside from complaint issues, on the training itself, witnesses have indicated that to say, A, the training is deficient in terms of time for board members, and I think that we owe it to board members to ensure that they have adequate training, and then, of course, the follow-through, the follow-up with that training to make sure that that training has been effective, and if they need additional support, et cetera, that is provided to them. If you don't do that formal evaluation, you will have no way to ensure that that training has been effective and that the optimal outcome is going to come out of that training. So that is the point. So this is important in terms of a process point of view, but also I think optimizing the outcome that is for everybody's interest. So is, I guess, is it the intention of the IRB then to not look at this issue of ensuring that there's a process to ensure that the training has been effective for those who's been sanctioned and on a regular basis for those board members?
It's certainly not the kind of thing which we would ignore. I mean, the organization is sensitized to that, and the training will address that.
So what is the formal process of that then?
Well,
you say that this is not something you would ignore. So then, what is the formal process? Because
I'll give you an example.
What I've heard is that I haven't heard a process.
So I'll give you a concrete
process.
example. I'm going down tomorrow on Thursday. The Immigration Appeal Division is conducting a national training session, which is focusing on cases which have been returned from the federal court, where the federal court has been particularly critical of the Immigration Appeal Division, whether it's in relation to things like the particular use of language in IAD decisions, or whether it's in relation to questions of what the court perceives as a lack of cultural sensitivity. That's a specific example where that division, is focusing on the response of the federal court to the way that division is dealing with particular cases, and it's because the members there are prepared to reflect upon themselves and to look at themselves and ask themselves whether they're doing the job properly.
Okay, well, thank you for that, but that
very
doesn't answer
briefly.
my question, I'm afraid. I'll just leave it at that.
Okay. Mr. Sarai.
Thank you, Chair, and thank you, Mr. Adderman and Mr. Kipling, for coming. Mr. Adderman, do you think the current, I'm going to actually pick up from where Ms. Kwan had asked initially. If you can't sanction someone to return, and I found it troubling that a lot of the complainants before, when a complaint is made, the member quits or is moved or is somewhere else, and therefore the complaint is never fully addressed. Do you think that under the new measures you'll be able to do so? And if so, how will you be able to get the evidence of a member who leaves when he finds out there's a complaint on them, he or she finds out there's a complaint on them?
Right. So, for example, I know, for example, that the Canadian Judicial Council and I believe the Justices of the Peace Review Council take the view that when a judge or Justice of the Peace leaves their office, the complaint is closed. So the approach that we're proposing is distinct from that. It's not the same as that. There are instances, I think, where, as a practical matter, it may be actually difficult to sort of get all of the information out. But, one approach that we can take in relation to that is to say to the member who has departed, this complaint has been made against you. We realize you're no longer a member of the board, but you have an opportunity to tell us your side of the story. And if you decline that opportunity, we may go ahead and make findings notwithstanding that. So it's not depriving them of an opportunity to put their perspective forward.
So it'll be a voluntary thing. In the past, you're saying that opportunity is normally not afforded to the departing member?
Well, we've had, to be frank, we've had very, very few instances where a member has actually left. There's the one which, was the focus of this committee study. So the issue hadn't come up before. But now that it has come up, the approach I think that we would take in relation to that is there's not a problem from a due process perspective if we say to the person, even though you're no longer a member, here's your opportunity to tell us, and if you decline that opportunity, we may go ahead and make findings anyways. Now, I can't say that that's going to happen in every instance, because it may turn on the facts of a particular case where we actually are not in a position to do that. You know, so there's that problem. But in many instances, I think we would be in a position to do that, which is why, you know, it's something which I think it's in the board's interest in terms of transparency and accountability to pursue that.
I think it should be pursued because it won't allow for closure if you don't pursue that. The second question I have is more to do in support, and it was heard just even prior to you speaking by the panel earlier, that current board members don't have, or perhaps don't have, adequate support. They're kind of the judge and a court clerk all in one, and they're doing a lot of support stuff. Do you think that is true, and do you think current board members need more support staff to make their workload easier and more efficient?
I think in terms of the way we're allocating resources internally, you know, members would always appreciate more. It's a question of sort of balancing that against the pressures of the organization. So the overriding concern that we have right now, and particularly in relation to the money which we've received in the budget, is to focus on finding available decision makers. And that is job number one for the organization. And, you know, if we find more decision makers than we have support staff to support them, then we're going to have to make do under those circumstances. Because at the end of the day, the most important thing for the organization to do is to address the large numbers of pending claims. And it's only decision makers who can decide cases.
But the decision makers, if they're spending too much time on administrative work, that might impede their ability to make decisions quickly. That's what I'm getting at. And you're saying currently the support staff is not the issue; it's the lack of people that are in the position of making decisions.
That's correct, because it's a highly specialized skill. It's not easy to find people and train them up very quickly in that particular area. That's the biggest. From a human resources perspective, that's a far bigger challenge for us than the support end of things. The support end of things is not what I stay awake at night over. It's more, can we find enough people who can decide claims fairly and quickly?
And what would be the biggest impediment to finding people in that position? What's the current challenge that you're facing? Why would people not be applying for it that are qualified and are the types of adjudicators we would need?
Well, it's temporary funding. It is, you know, you have to be able to attract people for enough time that they want to leave whatever it is that they're doing to come to the IRB.
So the length of tenure that is offered, that is the primary challenge?
Well, I think that's the challenge that we're facing at the moment with temporary funding, yeah.
And would part-time positions, I'm just curious, where people can do their existing career or wherever they're working and do this on top, is that a bridge that helps alleviate that?
It does, and we're making use of that. We've brought the legacy team, for example, is composed largely of former members who are retired, who are working part-time. So, you know, and we're beating the bushes to find people of that type. But, you know, they come, you know, with experience. They get up to speed very quickly. We are making increased use of part-time decision makers. And, you know, we're not ruling anything out in terms of where we find people who can do the job.
Time?
We have about half a minute.
I'll pass it over to the next.
Okay. Everyone else takes half a minute, makes it into a minute, just to let you know. Mr. McGuire.
Thank you, Mr. Chair, and thank you again for being here today with us. I just wanted to note, Mr. Adderman, that back in March you stated that there were, of the 425 cases, there have been 144 decisions since June. There's 21 that were founded complaints, I believe, was what you indicated at that time. And so I just want to know, in your view, does the number of complainants in number of complaints in proportion to the to the number of decisions that we've had, or the number of 425 number. To that number of complaints, is it in proportion to the number of decisions? Does it justify rethinking the complaints process of the IRB? And if so, can you explain that?
Well, so my purpose in making that comparison was simply to try to put that, the number of complaints in perspective against the number of decisions that are issued by the board on a daily basis. It doesn't mean, however, that an individual complaint is not important and shouldn't be given all the due process that's needed, because the problem that we have, and it's, I think, graphically illustrated by the cases that were in the media, is that one or two incidents have the potential to drag down the reputation of the organization and the good work of the many other people who do this day in and day out and have no problems. So that's the reason for focusing the attention on it, and that's the reason really for revamping the process.
So you're talking about the vulnerable individuals, and as the members hear a lot of these cases around these vulnerable individuals, how does that change the consideration of the complaints process, or does it?
Well, I mean, the complaints process tries to accommodate vulnerable individuals. There are specific provisions in the revised procedure which address that. So we'll make accommodations if someone for example feels that they would be re-traumatized by having to go through the whole thing again. We rely heavily on their representatives to advocate on their behalf, and we'll deal with a representative, for example, in terms of processing the complaint.
And I guess it was back in, thank you, and back in February, we were looking at under the new complaints process, the Office of Integrity. It will post the annual report of the IRB website listing the number of complaints, or listing both the complaints and their outcomes. Just wondering, with keeping privacy in mind, what aspects of this complaints process should be published in order to promote the transparency of the complaints process? I know we referred to that before, but I'd just like to get a bit more clarity on it.
Yeah, so what you will see, and I'm working on one instance which will shortly be up on the board's website, is a set of reasons which is anonymized, which basically describes the problem, the allegations against the member, the findings that I'll make in relation to that, and the determination as to whether or not the complaint is founded. And the things that it won't include are names, the location of the board where it took place, so that people can triangulate and figure out who it might be, so that they're anonymized. And the purpose of doing that is to ensure that the public looking at that can say, it doesn't really matter who it was, or where it took place. This is the allegation. This is how the board responded to it, and they can judge for themselves as to whether it's satisfactory. Mm-hmm. So it won't be a two-line thing. There'll be fairly extensive reasons which go into detail as to sort of what was alleged, what was determined to be the case.
And and it's very clear you have that responsibility under the new complaints process or procedure. And so with that responsibility, and as the acting chairperson now, providing the decisions on the complainants, just wondering if you can elaborate on the advantages and maybe some of the drawbacks that you see of having the chairperson exercise that significant control over that complaints process.
Well, I think the advantages, ones I've outlined, I think the organization, the perception of a lack of accountability flowed from the fact that this was a very diffuse. It was basically spread out over 4 divisions and 3 regions, which is basically 12 different decision makers involved, and inconsistencies in the way in which that was done. And it's now centralized. It's centralized in the person who's accountable ultimately to the public and Parliament. And so, I mean, it's probably evident to you I'm an advocate of that I think it is an appropriate solution, so I don't actually see too many drawbacks with it.
Thank you very much. Mr. Tabera and Mr. Whalen, I believe, are in this next round.
Yes, correct. Thank you, Mr. Chair. Two things. So I understand the training process can be ongoing, and there has been training done in the past, and it's still ongoing with the gender-based analysis, as you mentioned in your testimony. But in terms of the complaints, and I asked this before, and going on to what my colleague was saying, shouldn't there be maybe, I shouldn't say shouldn't, but should there be another layer in terms of when it's a complaint process, when some adjudicators have 54% with claims having designation of no credible grounds, and then other adjudicators have 24% or 28% to 30% with that designation. I understand having the evidence, the discretion of the adjudicator, having the evidence at hand and making that decision, but once that is an ongoing process and that's been going on for years, shouldn't there be a flag saying that, this is, between these two adjudicators, there's something wrong here?
Well, so the issue, respectfully, is a question of what tools do you use to address which problem. And, that's not a problem of conduct. That's a problem which relates to consistency or perception of inconsistency. And the ways in which that is addressed, and I should have, I don't think I was clear enough on that in my past appearances with the committee. There are, both in the Refugee Appeal Division and in the Refugee Protection Division, structures that are now set up which deal with the whole question of consistency. So the RAD, the Refugee Appeal Division, has what's called an Adjudication Strategy Committee, which is a group of members. It's not management, it's members who are meeting together, and they're looking at issues of concern to the RAD from a consistency perspective. So they're doing statistical analysis as to whether or not there is a consistency problem. Because oftentimes it appears that there's a consistency problem and there's not. If you look at a country of origin, that is not necessarily the indicator, just a divergence between members on claims from a particular country of origin is not necessarily an indication of inconsistency. I'll give you a particular example of that. We have claims from China where sometimes the claimant says I'm being persecuted because I'm a member of Falun Gong. Another claimant says, it's because I'm a Christian. Another one says it's because of my political beliefs. So it's claim types within a country, which gives you a more granular and meaningful indicator of whether or not there is a consistency problem. It's not sort of based upon which country of reference it is. In the Refugee Protection Division, they've set up groups which do this, it's members talking to members about whether there is a consistency problem there or not. In any adjudicative system, whether it's the IRB, the courts, the federal court, any tribunal, there's an ambient level of inconsistency. It's because humans are deciding these cases. I don't know what the optimal range of variance ought to be. And I don't think anybody else does. And with all due respect to Professor Rahag, I don't know sort of what he's measuring our inconsistency against. Yes, when you have extreme outliers, it's self-evident. It's just a matter of common sense that there's a problem there. But what's the range?
If I can just interrupt just for a minute, and just if I can ask you to maybe submit any more further information on consistency, I just want to pass it over to my colleague.
For sure, yeah, we can do that.
Thanks, Mr. Edelman. I'm getting a sense today, a stronger sense that the measures that have been put in place over the last year to address the issues regarding SOGI guidelines and member appointments and the complaints process are there, and it would be great now to give it some time to see them work their way through. Another issue that arose newly today with Ms. Warner's testimony earlier is the role of a clerk versus the role of a member at the lower levels of the Immigration and the Refugee Division, and how that work is managed, both from the perspective of your role as the chair to make sure the organization functions properly from a labor relations perspective, but then also the independence of members to make decisions. And, you know, at a fundamental level, whether or not we have some inconsistencies in approach here and how your organization is attempting to address those inconsistencies, because it does not seem like the traditional employer-employee relationship vis-a-vis the members. If you could speak a little bit, you were in the room, so perhaps you remember her testimony a bit, some of the challenges and how you address appropriate staffing and also the mix of relationship that you have with the members as both their supervisor as well as their chair.
I mean, there's certain aspects which are sort of inherent in the board's business, which change the traditional employer-employee relationship. To give you an example, I'm appointed first as a member, and my substantive position is as a deputy chair, but I'm first a member and then a deputy chair. And when it comes to discussing cases with other members, my voice is no louder and doesn't carry any more weight than any other member's does. So, you know, when I talk to my colleagues about decision making, I'm doing that as a peer. And we have to manage that relationship along with the traditional employer-employee relationship. So, you know, the big issue for us on a practical level is being able to differentiate when is it a matter of member independence and when is it a matter of, you know, the employer-employee relationship. And it's actually the complaints process and the, you know, has highlighted much of that, because a lot of the time, you know, we didn't deal adequately with complaints against members because we characterized those things as adjudicative matters as opposed to conduct issues when they were in fact conduct issues. So it's not an easy. There's no bright line there.
Well, then I need, go further.
I need to end you there. Sorry. You will get one more minute if Mr. McGuire gets 5 minutes, and then we may have time for one or two more minutes. No, you'll get more time. You're on the list.
McGuire just agreed to hand me a minute of his time.
Okay.
Oh.
you will get it anyway, because we have 5 minutes and then two.
Okay.
Thank you, Mr. Chair, and I will be glad to, I'm sure there'll be a moment or two for my colleague when I'm finished. And just wanted to know, we have a great backlog in the number of cases, the case backlogs right now in the IRB. So I just wonder what you think of the long times of hearings. Some of them are several years. People have been involved and of course waiting to get into Canada. So what impact on an asylum seeker's ability to recall the details does drawing out this long termination before they may be able to come back to a future hearing have on them? Are you concerned about that, or I mean, how do we deal with that?
It is a concern. You know, sometimes the nature of a particular case is such that it can be dealt with very quickly, and other times, you know, the substance of what the claim is about means that it's going to take place over several sittings, and those then get scheduled sometimes over months and even over years. And you know, as I indicated to you, it does have an impact on people's recall. It's never good for us to be stretching these cases out over a protracted period of time. I don't know if perhaps Mr. Kipling can sort of speak to you about, you know, the average processing times and sort of where we're at in relation to that.
Right. Well, and what I could say is, you know, as this committee may know, we are close to 19 months for average wait time for claims that are referred today. So it is a reflection of the intake that we're facing and our ability to process the cases with us. But this is where the influx of the temporary funding will assist, obviously, by increasing our capacity to hear and decide more cases.
The complaints system is still dealt with internally in the IRB, as I understand it, but as we've been studying with the quasi-judicial boards, it appears that that such as an example as the Justice of the Peace are largely regulated under the Justice of the Peace Act. So do you think the federal government should make amendments to the IRPA to institute the proper complaints process there as well?
Well, My understanding is that there's a distinction between sort of judicial officers, judges, justices of the peace, and administrative tribunal members. I don't know of any tribunal complaints process. Actually, no, sorry, that's not true. In Quebec, they do have an external body, but other than that, I'm not aware of any that sort of review complaints externally. And I don't have any expertise in that area, but my understanding is that because judges are not, don't have limited terms, and their tenure from a constitutional perspective is such that it has to be protected, that you have those extraordinary measures like, the Canadian Judicial Council, because that really only sort of deals with instances where it looks like they're going to remove a judge from office, as opposed to, a question of whether or not a particular judge in a given instance was rude to someone in their courtroom.
Thank you. And I'm just, my last question will be in regards to the complaint process as well. It doesn't clearly list the possible outcome of the complaints. And I'm just wondering if, by contrast, as we looked at it's been referred to earlier, the Justice of the Peace has a very clear list of the outcomes of complaints. And so I'm just wondering if you could commit, or would you commit to making that possible reprimand list public as well?
Well, I think as I indicated to Ms. Rempel, I think we could indicate what the range of possible sanctions is, within the board's authority to impose, whether it's for public servants or GICs. The one thing which I just would like to underline is that on the GIC side, it's the governor and council who appoints. So the board has no power to actually remove a GIC appointee. It's only the governor and council who can do that. And that's through a process which is spelled out in the Act at Section 176 and onwards.
Thank you.
Mr. Whalen for 2 minutes.
Thank you very much, Mr. Chair, and I guess I'll follow up on the previous line of questioning. So when we had Dr. Professor Flaherty here last week, she'd mentioned the characteristics that we'd be looking for in the quality of an administrator and adjudicator. Consistency, obviously, in decision making, competence ultimately in the law, the right temperament or conduct, and then, of course, the ability to efficiently do the work were things that were raised. It seems to me that the complaints process only addresses the conduct aspect. It doesn't address the other three areas in which somebody might have decision or questions about the decision making: consistency, legal competence, or efficiency in operating. How are those other three areas addressed in your management of the IRB?
So no, you're quite correct. The complaints process doesn't do that, and in my view, it shouldn't do that. Those are issues which have to do with how well the person's doing the job, not how they behave towards other people. And, it's training, it's the evaluation process. Those are the tools that we use to address those. In the case of GICs, I mean, we have a good process for recruiting people. It's extremely rigorous. 1 in 10 people, whether it's on the public service side or the GIC side, it's only 1 in 10 who will ever qualify to even be considered. It's quite rigorous, but that said, it's not perfect. And we appoint people sometimes who turn out not to be able to do the job. On the GIC side, you have term limits, so it's dealt with that way. On the public service side, they're the disciplinary mechanisms associated with that, and they are used. It's a slower process.
Maybe this is probably my last question, I guess, on this point. So, I know you don't want to try to make the decisions, but we need to come up with recommendations on this very issue, and we look to you as the chair of the IRB for your view on what would be more optimal for the organization. I mean, would it be better to have clerks operating in a clerk function as civil servants, professional civil servants, and that the adjudicators be independent GIC appointments, so that the process by which they could be removed for issues related to consistency, competence in the law, and efficiency would be addressed at the reappointment stage? Do you have any views on which would be better for those lower two divisions?
No, there are advantages and disadvantages, with respect to both employment regimes, but fundamentally that's a choice the government's going to make in terms.
I need to end there. Just a reminder to the committee that we will be meeting on Thursday. We will have a panel. There's only one witness appearing, so I'm going to be proposing you'll get a notice that we slightly shorten that panel. Then we'll have drafting instructions for slightly over an hour on Thursday, so we can do this. Thank you very much to the witnesses. Thank you for coming and your involvement in our study. Meeting is adjourned.